Welcome back, everybody. For the very last session of what has been a very full and engaging day with lots of ideas, and in which we have also, I think, covered an extremely large terrain already. My name is Anja Kovac. I work with the Internet Democracy Project based in Delhi in India. I'm actually originally from Belgium, if there's any confusion about where exactly I come from, but have been living and working in India for more than 10 years, and the past few years have been specifically on issues related to what the internet does to democracy as a system, especially from the point of view of developing countries, and more specifically also on freedom of expression issues in the internet. And as some of you may know, since December especially, the whole debate about intermediaries has really flared up in India. An intermediary is basically any internet actor that doesn't actually produce content, but that stores it or transmits it. So strictly speaking, the actor is not changing the content in any way. And intermediaries can be a very broad range of companies. So a search engine would be an intermediary, a social network would be an intermediary, but an ISP, for example, is also an intermediary. So there are a very wide range of companies. We've recently seen in India the whole question of to what extent should intermediaries be held liable for the content they place on or allow on the internet. And the debate, just like here, has been phrased a lot around the specific issue of hate speech. So a lot of what we've been talking about in the morning, I think, really reminds me of what happens there, some 8,000 kilometers away. If you want to control hate speech, and I think a lot of the debate has been about that, should we control, should there be legislation? The best groups, at least on the internet, then to control are actually intermediaries. If you manage to legislate, control, regulate intermediaries on these issues, you will actually be controlling a fair amount of the traffic on internet. And definitely of the most popular traffic, because almost all over the world you see that the top 10 of internet websites are actually mostly intermediaries. So the big question, I guess, is should we regulate or not? And then how should that regulation happen? And we have four distinguished speakers who are going to address very different angles to this topic. First of all, I'm very happy to introduce Giovanni Sartor, sitting next to me from the European University Institute, who's done extensive work on jurisprudence and on internet law and legislation, and has extensive experience in the area. He will specifically introduce the European legislation on this issue. Giovanni.
Okay, thanks a lot. I have prepared some nice slides, but I don't know how many you will be able to see because time available is very short, as you know. So let me go on. So what I'm going to focus is on the liability of intermediaries for user-generated content. That is the content that internet providers store in their websites, maybe the blogs of the users, maybe online repositories of various materials, maybe social networks, maybe online forums, etc., etc. So the issue is whether providers should be liable for thoughts of crime committed through this information, in particular whether they should be liable when hosting material whose posting is illegal, but also by taking down material such that its posting is legal. And in the first case, the material is offending privacy, copyright, equality, dignity, hate speech. In the second case, when we download legal material, we are offending freedom of speech, political and economic freedoms, etc. So let me go quickly. Both in the United States and in Europe, we have legislation which gives providers some immunities. And in the UI, there are two pieces of legislation. In Europe, we have the e-commerce directive. I go quickly because time is tyrant. So The argument, I assume that you know the basic argument. Should the provider be liable? Yes, because it profits from access to the hosted information. It can be identified and has the resources to pay the compensations. And then, most importantly, because by making the provider liable, we put pressure on the provider so that offending content is removed or is filtered out. And then you may say, maybe it was useful to give immunities to the provider when internet was starting. Nowadays, some providers have huge resources, so why not? Why shouldn't they pay? But then there is the other argument. They should not be made provider because they did not create the content. By making them liable, we put cost on them that would put at risk the current business model, universal access without payment, and then provider will likely exceed on censorship in the sense that there will be, for the provider, the most convenient option is when the provider is liable is to remove content. Preventing any chance, even small, of being then made liable. There are different models. I will go quickly through these different models so that we can have a look at what kind of model may be more appropriate for today's subject, that is hate speech. One model quite interesting is the notice and takedown model, which was adopted in the Digital Copyright Millennium Act in the US. In this case, a provider is completely passive. There is the right holder, the person who affirms he has copyright over the content which is distributed online. He sends a notice to the provider. The provider at that point should take down the material, but inform the customer, the one who put up the material. The customer may object, and in that case, if the right holder does not start immediately a legal lawsuit, does not go to court, the provider has to go put back the material. Good points. There is also an immunity for removing the content by the provider. But the good points of this model is that the provider does not make any assessment on legality or illegality of the material, and the uploader is involved. There is an interaction where both parties can express their views. The risk is that since the provider reacts to every request to take down, the risk is to take down material which, as a matter of fact, is legal. Second model you can find in the Communication Decency Act in the US. In this case, we have an absolute immunity for the provider. The provider is not responsible, and there is a very limited possibility of injunction against the provider. Even judges have problem in obliging the provider to remove the material which is online. However, the provider can screen objectionable content and even delete that. Therefore, providers are allowed to engage in censorship to maintain civility, which is okay if it is done in good faith. So this is another model. Then we have the European model, which we may say basically there is immunity when the provider does not know of the illegal material, or when getting knowledge removes the material from the website. I will not go into the details concerning what member states cannot do, since we have no time. The European model, I think, has some problems. In particular, what is knowledge of illegality of a piece of content online? For instance, the knowledge that this is an instance of forbidden hate speech. The provider must know that a certain piece of content is on its servers, and then the provider must know that the content is illegal. What is knowledge of illegality? And this is an interesting issue because, as we know, in these cases there is a vast area of penumbra between legality, the light of legality, and the darkness of illegality. And what to do with what is in the middle is a big question, very difficult to answer for the provider. Provider should anticipate what the judge is going to say. but who knows? And even this inquiry may be expensive and in any case uncertain. We have a fourth model, which I may call the administrative model, when we have a public authority instead, which gives at least presumptive indication on what to take down. Maybe a law enforcement model, maybe an independent authority, such as we have in France for copyright, and also in Italy there is a proposal of having another similar authority for copyright, and in the domain of data protection, the data protection supervisors in Europe play this role. In this case, the public authority is a kind of filter on unreasonable requests to take down, but it may be difficult to challenge the decision of this authority, and in contrast to what happens with the US model in the Copyright Act, the uploader is not involved in the process. To conclude, let me have a look at a proposal that was circulated some time ago by the Commission concerning a recommendation for dealing in particular with hate speech. And in that case, the proposal is interesting because it gave an important role to users and to their organization in order to influence the behavior of providers. So, according to this model, to this draft recommendation, when there is a request which is legally binding, obviously the provider takes down. When there is a notification from the citizen, the provider has the obligation to take down material in case the content is clearly legal. Consider hate speech. In case there is a notification from a law enforcement authority or from an authorized complaint hotline, there is the obligation to take down unless the content is considered to be legal. And in this case, the provider has to notify authority. This model, according to myself, has a lot of problems, as it was remarked also by the internet providers who presented an objections to this proposal. And in fact, the proposal has disappeared from the website. It's not in the website of the European Union currently. There is no right for the uploaders to counterclaim. They are excluded from the project. It is not clear what happens if the provider takes down material which happens to be legal. It is said that the provider have the possibility of freeing themselves of responsibility through contracts with users. And obviously there is an incentive to censorship, because censorship is the safer choice for the provider. So according to this proposal, just to show you how it is difficult to tinker with the internet regulation, providers should categorize materials into three classes: what is certainly legal, what is possibly legal and possibly illegal, and what it is certainly illegal. The problem is how shall they classify the materials into these three classes, and what to do with material which is possibly legal and possibly illegal. Again, the safe choice is always to take down the stuff. I conclude because there is not time left, I think. So, what should be the conclusions? I think that provider cannot and should not have the obligation to prevent online hate speech. Unfortunately, I see that prevention was in the title of the conference, but there's not much we can do, I think, on that. Letting hate speech come online may also be in a way a good thing, because hate comes to the light. The society can express its judgment, and appropriate decision, possibly to take down the material, can be taken. And we may also wonder whether victims may have a right to respond on the same place where the offending material was presented. Providers, at least in Europe, may be compelled to take down hate materials, but I think they should respect the adversarial principle unless the material is anonymous. Possibly the obligation to take down, in any case, there should be at least a representative authoritative assessment for this obligation to start. But judges should have the last word. That is, whatever administrative decision is taken, it should not be definitive of the issue. I'm finishing, yes, just last sentences. So, providers should not be obliged, I think, to assess the legality of material, but they should be permitted to take down in good faith inappropriate materials. And what is inappropriate, I think, should depend on the kind of platform that where the material is put, considering in particular the possibility of users to avoid exposure. Therefore, I think that on a website owned by an individual or by an entity, there should be the largest amount of freedom to put materials online. And this freedom may be restricted when dealing with blogs that are presented on a certain platform, and even more when dealing with repositories such as YouTube, when you access and you are usually exposed to whatever material is there. And finally, I think that it's very important that uploaders are given a role and are enabled to express their opinion, and this opinion may be challenged, and this may also be an educational exercise. So, thank you for your attention. I stop here, and thank you for your patience in giving me some additional minutes.
Thank you, Giovanni. Thank you for this overview of all the legislative responses that are kind of in circulation right now. I thought it was really interesting that you, in the very beginning, mentioned that some people see the fact that intermediaries nowadays make quite a lot of money as supposedly a reason why they should be held liable for content that's online. I thought that was another very nice indication of how the commercial spirit has imbibed so many of our responses that we were talking about earlier. We'll next turn to somebody with a very different perspective, I think, Brankica Petkovic from the Center for Media Policy at the Peace Institute in Slovenia. Brankica has been editor of Media Watch journal and the Media Watch book series earlier, which was established initially specifically to deal and monitor hate speech. She's also been involved in developing a range of indicators for a media pluralism study, and in general has been involved in a whole range of debates on media pluralism in Europe. And Brankica will speak specifically about alternatives to the legislative approach, looking at self-regulation and co-regulation. Brankica, I'm going to ask you to stick to 8 minutes, and I'll be more harsh now.
Yes. Maybe in this panel surrounding with so big legal and technological experts, I even have nothing to say more than 8 minutes in this company, because my prior expertise is in traditional media, media freedom, and also hate speech rather in traditional media context. But what I'm bringing to this panel is a story from Slovenia, an interesting attempt by traditional media industry with their online presence and online news media to self-regulate in context of dealing with user-generated content. Why they are doing so? I think they are developing this alternative in connection to traditional legislation, penal code, but also self-regulatory instrument of the Association of Journalists, which both make editors-in-chief also liable for publishing material that promote or incite hatred. So editors-in-chief joined the Internet Hotline initiative that is run by the University of Ljubljana in an attempt to adopt joint rules. So they introduce or commitment, they commit themselves to introduce moderators to all of their online news websites, news media in the same form, and also to request oblige registration of users in the same fashion, and also introduce the same form to report hate speech to the hotline internet hotline. So they have the common appearance online, how to deal with users in posting their comments and reporting on hate speech there. So what is the co-regulatory element in this is that this hotline, internet hotline point is receiving these reports from all moderators of the media that are part of this self-regulatory attempt, but the hotline itself is connected to police. So the first filter is done by moderators within the media, then the next one is by hotline, and the third step is police as the state. So this is the co-regulatory element in this. It is obviously very good development that as I heard in some media, there are even no any policy towards comments posted by users on news media. But still, in a way, it is given, how to say, big temptation to moderators how to deal with it, you know, and there are obviously through research indicated very different perceptions on what is hate speech in these comments. So I will ask Anya now to show these statistics. This hotline is receiving reports, complaints about hate speech in these user-generated comments in online media, and they receive it. You can see that it is increasing. The first column is how it is increasing the number of reports, complaints they receive. But you can see the next column is how many of these complaints they proceed to police, you know. And then the last one, and if Anya can show the next table by the police, this is statistics by hotline, is what police then take and investigate is the first column. So you can see from 800 in 2010, only few are taken really by the police. But if you see the last column, that is what is taken and proceed by prosecutors, none. So this is, or one in 1 year, which is connected to physical attack to gay and lesbian club. So what I want to say is let's debate this exercise in a way that it is obviously very welcome, that the whole community that participate in internet news publication and commenting is dealing with it, is watching, and also users watched. The eye is symbol of this report. So everybody who is posting comment see this eye, that it is possible that the moderator or another user will report it. But at the end of the chain is zero. So the zero, it is prosecutor who is dealing based on national legislation, on penal code, and which understood and consider and interpret the penal code article very restrictive. So there should be physical, concrete element of incitement, otherwise they are not taking the case. So my point is that it's good to deal with it in a way that we engage in proceeding and watching this. But it seems at the same time that there is not much changing at the end of this chain. Human rights activists, as I am part of them, are sometimes not very happy with the end of this chain. How it is possible that public perception, users' perception is, you can see for the hotline statistics in 2001, it's almost 4,000 of reports and zero prosecuted. So is there any problem? What is very important with this attempt is that there have been several meetings between media editors, police and prosecutors' office and us civil society debating at workshops various aspects of this issue, regulation and the hate speech online itself. And it is obviously a constant debate needed how to deal with it, not to criminalize the very participation of users in this, but also to empower those who are filtering, like moderators in this process. Anya, you are saying I'm to finish. The last point I would like to make on generally, because as Anya said, and as I was commenting of my very ability to discuss internet freedom in this company of my colleagues in this panel, is I would like, where I feel comfortable to debate hate speech, to come back to the bigger picture. You know, I now presented to you one attempt to assess this problem. But I think when we are debating hate speech in the media and generally in society, we have to take into consideration broader social and political environment. If we just focus on manifestation, and especially if we focused on journalists themselves, I think we are missing the point. We have to question the society and social and political order as such, because we cannot deal with hate speech against Roma, which is the field where I am most active in empowering Roma and in dealing with hate speech against Roma, is just with dealing with intermediaries or media and so on, because there is something very wrong in the society and political environment when we have to block any comment in Slovenia and in many other countries around us if the news or report is about Roma. Because if you open it for commenting, it's immediately a lot of hate speech inside. So instead of discussing how to regulate this part of the story, we have to see what is in our society and in our political environment that encourage and produce such sentiments to certain groups, and what are arguments and discourse and policies that feed these practices. Thank you.
Thank you so much, Brankica, for that example. I think it throws up so many questions, including about still the role of the police and clearly some legislation there. But also I was wondering whether just the fact that there is a more inclusive mechanism through which people can actually communicate at various levels their concern with certain content, whether that contributes in any way to the kind of discussion we've been flagging several times today that one needs to have in societies to battle these kind of things. So maybe this is something we can come back to later, whether just the fact that something like this exists actually has diffused some of the tension that might exist around hate speech. But before we continue on things like that, let us move to Marco Pancini from a senior policy counsel from Google based out of Brussels, who's also been active, among other things, in internet governance processes and has looked at the larger policy implications of these issues. Marco will talk a little bit more about how Google in particular deals with these kind of issues.
Thank you, Anya, and thank you for having me today. For me, it's a pleasure and honor to be with such distinguished speakers and point of reference, like, for example, Frank, which works is for us really an important point of reference in everything we do around free speech. I'm dealing with intermediary liability and free speech issues in the Brussels office, which means that I am basically working at the core of Google mission, which is making the content online available and useful for a user. Which means also that we are dealing with these kind of issues that we are discussing today every day, where we draw the line between what is illegal, what is not illegal, how we can, how to deal with the request of takedown that we are receiving every day without entering into censorship. Now, as we say today, the new technologies are an incredible tool to empower people. And we believe that people with more information are people more free, more eager to make decisions, and in the end more active in the social debate. But at the same time, we know that new technology can represent a threat, as was said several times this morning and this afternoon. So how to deal with this problem? First of all, we need to think that censorship is a concrete problem. If we only take in consideration our services, since we launched Google, the search engine, our products were blocked in 25 out of the 150 countries where we offered our services, and in 70 countries YouTube is still blocked. And these countries, in this list of countries, you can find China, Iran and North Korea. But this is not only about the so-called non-democratic countries. Actually, we need to always think that the censors are looking at us, so we should not be surprised that, for example, like a few months ago, Gaddafi is issuing a press release on celebrating the riots in London, or the Chinese are using the proposal that are pushed by European institutions and European states in order to see that they're going in the right direction when they say that they want to protect internet, the Chinese user internet security and their critical infrastructure. But at the same time, for sure, as I said, we need to face with the reality of controversial and illegal content online. So what is our approach towards that? We have a bias for free speech, which means that our first point of reference is to let the content flow. If something is illegal, and as I said, the illegality for us should not be considered in relation specifically to the internet, but should be assessed in consideration of the legal framework, which include also the offline world. What we do is to take down the content if we receive a court order, if there was a clear due process of law. On the search engine, we don't host the content, we only host a link which is going to a content available online. So in this case, the only thing that we can do, and we do, is to remove the link from the index. But again, as was said, the role of law enforcement in looking after and following up with investigation this kind of content is dramatic, is very important. For the content that we host on our platforms, what we do is to receive a request of takedown through our flagging system and through due process of law from all the interested parties, and taking action when we have to, always giving the opportunity to counter notice to the interested parties. I would like to close with two important principles that we think should be put as a balance to protecting user online. First principle is transparency. We apply transparency to every and each request of takedown that we receive through communicating, for example, for search engine, request of takedown from search engine links to Chilling Effect, which is an NGO organization doing an incredible job in collecting information about takedown online, and through our transparency report that is developing more and more, and we hope to be able in few months to provide a full picture about the takedown that we are taking. Second initiative that we took, because I truly agree that censorship is not the winning weapon against hate speech, is to think out of the box solution on how to counterbalance and to fight against hate speech. One of these is an initiative from Google Idea, a think tank that we have founded, called the Formers, which means that we want to put in the dialogue with the extremists, formers, ex-extremists that are able to speak the same language and counterbalance the opinion and create a real debate around these kind of things. When I say we want, it's not that it's Google pushing for formers to get into the debate, but we created a framework in which the discussion of this idea could develop, and now we are really looking forward to having the civil society to take over and push the idea around the formers forward. So thanks, and I hope I stayed in the time. given to me.
Thanks a lot, Marco. I'm not really going to comment on anything you said, because I think our next speaker will do part of that. It's Joe McNamee from the European Digital Rights Initiative, an association of 28 civil digital rights organizations from 18 different European countries. They've been working on these issues for 10 years now, and so definitely we're one of the pioneers in the field. And Joe will look a little bit more in detail at some of the big challenges that come with the privatization of censorship that intermediary liability by definition entails. Joe?
Thank you very much. I'm glad that it's my turn to speak, because that means I can finally stop rewriting my presentation. It's very difficult to summarize everything into 8 minutes. The issue of what intermediaries can and can't do in relation to content that is either illegal or legal but potentially harmful is an extremely complicated one. Regulation in this area is a little bit like pulling a thread on a piece of clothing. It might just be a random thread, or it might be the thread that holds the whole garment together. The situation gets more complicated when the intermediaries are made liable for content that they didn't create, because that moves the private company from being neutral to needing to act in its own self-interest. And, of course, its own self-interest is not necessarily society's interest. It gets even more complicated when the unintended consequences for the online marketplace, for free speech, and for the rule of law are taken into account. And then it gets even more complicated again when the term self-regulation is used for the voluntary actions of intermediaries against its customers is used. Actions taken by intermediaries against their customers is not regulation of the intermediary of itself, and is therefore not self-regulation. It is the policing, judging, and prosecution of users outside the rule of law. There's a rather strange initiative in the European Union at the moment called the Clean IT Project, which is different from the Iranian Clean IT Project, to avoid any confusion. And their draft policy document states that what constitutes unacceptable use can only be determined by ISPs, not courts, ISPs. This approach is about as far away from established international law as it is possible to get, and even though it's funded by the European Commission, it's about as far away from the principles in the EU's treaties as it's likely to get. I'd like to briefly mention 3 points regarding intermediary liability. Firstly, intermediaries have different levels of control over content that they provide access to. Secondly, the worse the content, the more superficial the actions that the internet providers can take, and therefore the less private companies should be involved in regulation. And thirdly, and this is the point that is very often forgotten, is that the telecoms industry, and in this context the internet access providers, are the most instinctively anti-competitive industry that you're likely to find anywhere. And many of the discussions about illegal and harmful content in Europe are being shamelessly manipulated by certain large players in order to gain competitive advantage. In any area of life, if individuals or organizations are made responsible for activities over which they have no control or don't have significant control, problems will arise. The less the control, the greater the problems. This creates 2 layers of problems. On the one hand, the efforts of intermediaries to resolve the problem will, almost by definition, be ineffective, because internet intermediaries can only deal with the symptom of an offense. It can deal with the website existing, it can deal with access to the website, it can't deal with what the actual offense is. And on the other hand, the ISP will be taking pressure off the state authority to take action, to take the real action against the real offense behind the website. I'd like to give one example of this, and it's online child abuse material. I choose this example because it's more clear-cut than hate speech or most other forms of questionable online material. In a lot of European countries, there is a private organization. In the UK, it's the Internet Watch Foundation. In the United States, it's NICMEC, that make decisions about what's probably illegal or what is not illegal. And those reports are then given to the police and to the internet providers. And the result is, in the United States, that websites are taken offline very quickly if they're accused of containing this criminal material. So that's all good, in theory. According to data from the United States, the internet companies are so good at removing the criminal content that in 4 out of 5 cases, the police take no action whatsoever to investigate the crimes. So who wins on the basis of this action from the internet intermediaries? Well, the victims don't win because the crimes that were committed against them are ignored. The intermediaries don't win because their good faith efforts to deal with a horrible crime results in police taking no action. In fact, the only stakeholder in the whole process that seems to win is the criminal behind the website. If these are the unintended consequences of ISP liability and ISP voluntary measures in a situation where the crime is clear, the situation is exponentially worse in situations such as hate speech. And as bad as things are when it comes to content that's hosted by a provider, it's even worse when it comes to access providers. For the past 5 years, access providers have started blocking various types of content on websites in Europe. The problem with blocking is that it doesn't actually work. And the more objectionable the content is, the worse that blocking works. The only demonstrable effort is that it takes the pressure off governments to work together to investigate the real crimes. So the voluntary blocking that's being done isn't useless, it's actually worse than useless. And worse still, it is increasingly popular among the largest ISPs and mobile operators who, while portraying themselves as good citizens, voluntarily self-regulating to block an ever wider range of content. They started blocking child abuse websites. They've now moved into blocking websites that are accused of infringing copyright. And now they've started using a technology called deep packet inspection, which involves filtering every packet of data in order to identify the source, the destination, and the content. So now we have got European governments who are worried about anti-competitive activities of internet providers, demanding that they do not interfere in internet traffic, because that would undermine the online marketplace, and demanding that they do voluntarily act to interfere with traffic in order to prevent access to copyright material, racist material, whatever. If access providers strangle what we access, then the bi-directional nature of freedom of communication as well as the economic benefit of the internet is destroyed. The core problem is that Google and Microsoft and Facebook and any other company you care to mention hasn't the slightest interest in being the judge, the jury, or executioner when it comes to deciding what is appropriate or not. They want the easy option, and the easy option is to have terms of service which allows them often to do whatever they want. That's how Visa, MasterCard, and PayPal suspended payment services to WikiLeaks, even though WikiLeaks wasn't accused of doing anything illegal. That was how Yahoo deleted photos from an Egyptian blogger because he hadn't fully respected the rules governing uploads to the photo sharing site. It's how Facebook deleted profiles belonging to Chinese activists on the basis that they use pseudonyms to protect themselves in contravention of the real names rule. So if you still want internet intermediaries to regulate the internet, I just want to leave you with 4 interesting statistics. Firstly, as mentioned before, 80% of the voluntary child abuse takedowns in the US are not followed up by police action. In 2009, 1 out of every 3 reports to Google under the DMCA regarding copyright were not valid. Half of the reports that Google received in 2009 under the DMCA involved a company seeking to undermine the online activities of one of its competitors. One study found that 70% of Dutch ISPs were prepared to remove websites without asking any question on the basis of an anonymous report from a Hotmail account. And recently, within the last 2 weeks, it's come to light that reports to Facebook regarding potentially harmful content are processed in part by individuals in developing countries being paid $1 an hour. This is not the way our free speech should be regulated. Thank you.
Thank you very much, Joe, for this rather chilling presentation. I think the figures are really, really scary if you think the amount of time we spend on actually discussing legislation and if you see what then happens with it. We haven't actually talked about the chilling effect of free speech, but we could perhaps talk about the chilling effect of legislation as such also. But let's open up to the floor. Who would like to start? Dirk Voorhoff?
I have two questions, one for Professor Sarton and one for the last speaker. I thank Professor Sarton very much for, in 7 miles boots, you run through the difficult procedures or notice and take down. You warned for the dangers of this procedure, but at the end, the message was, if I understood you very well, that you would consider it acceptable that ISPs can be permitted to take down, I quote, inappropriate materials, be it in good faith, and depending on the kind of platform. Don't we introduce with such a word, inappropriate, a box of Pandora, which could be very dangerous, and when we leave the word illegal and we replace it by inappropriate, it's very broad. And also I don't see the content provider in this procedure. I think there is also a need for a broader transparency, how the internet providers apply such a permitted possibility. So if he could maybe comment a little bit further on the idea that you situated in the end. And then with regard to the introduction by Mr. McNamee, I understand that your message is, if I summarize well, blocking is not effective, investigate the real crime. My question is, are ISPs available to be under an obligation to reveal the IP codes or other personal information of the content providers in order to help police, prosecutors, judicial authorities to find and to retrace the source of the clearly illegal speech which is considered as hate crime in these situations? What is the willingness to really go on that track? Thank you.
I think it's a very difficult issue. On the one hand, I think on the internet you have a multiple of different spaces. So if somebody posted pornography on the Economist website, I think it would be fine if the webmaster took off the pornography among the comments to one of the articles of the Economy. So if there is a certain kind of pornography, for instance, that Google doesn't like it to be on YouTube because they think that YouTube is a kind of tool which is accessed by all kinds of people. Most of them don't like this kind of content. I would say it is fine if they take out the pornography from YouTube. So that maybe different editorial policies that internet providers take with regard to the different spaces they have. And I don't think that we should impose on them for every space that they made available. Imagine a space for children, games. Is it okay to have pornography there? I don't know. It is legal. Pornography is legal, but what about putting it in these kind of areas? So I think that basically, given this diversity, we should, in a way, enable providers of taking care of the kind of level of civility that they think is appropriate to each different space. Another issue, however, is to enable people to exercise their human and constitutional rights also online and also on the private spaces that are offered by the provider, which I see as a constraint. Yeah, this is the problem. To find the solution is difficult. Anyway, my statement would be that I don't think that we can impose on providers to accept every legal content on every platform they make available online, even when this is against the editorial policy that is appropriate to those platforms. Maybe we should check the editorial policy against the particular content that are posted to see whether it is legal to have them there or not.
And the problem of transparency, how can we know what the internet service providers are filtering away or taking away?
Yeah, this is another issue. There should be transparency on that. You are right. And something has been done, for instance, with regard to chilling effect, but more should be done to make these choices public in any way. And the voice of the uploader should be heard in any case. Okay, sorry.
Maybe just briefly to mention, you might be aware already, but there is something called the Global Network Initiative, which is trying to link businesses with civil society organizations, academics, etc. And they're trying to build a list of principles according to which businesses could act to deal with these things in a more appropriate way, I guess. It's interesting though, because to some extent I feel the discussion here is sliding from intermediary liability to what can be done under terms of service, which is not completely the same thing. Because obviously terms of service allow intermediaries to determine what can or cannot be done on their platforms.
Yeah, can I just, no, I was just saying, but also terms of service may be a problem when they enable they authorize action that will be against the human and political rights of the and constitutional rights of the users. So there may be a problem as well.
I'll ask Joe to respond, and then Marco also briefly wants to respond, and then we'll move on to the next two questions that I saw.
Okay, just to answer what Anya just said, I think terms of service are increasingly used as a safe haven for internet intermediaries. The more they're made liable, the more they give themselves a license to do whatever they want in order to delete content for which they might ultimately become liable. So the terms of service liability issue is quite closely linked. There has been a lot of work on cooperation between internet providers and law enforcement to answer the second part of the question. There were a set of guidelines produced by the Council of Europe in cooperation with the European Internet Service Providers Association in 2007. And unfortunately, if you look into the copyright field, you will see that there's a lot, if not too much, that can be done as regards internet providers handing over data in investigations. The problem is that the push is to let internet providers deal with online problems so that law enforcement don't have to. Thank you.
Marco?
Very quickly on the transparency, we think that this is a battle that we want to fight in terms of putting transparency even in regulation for what concern a request of takedown sent to internet service provider on the two sides, from internet service provider in relation to the action that they took, but also from institution, law enforcement, to make transparent how they deal with illegal content online. So that's absolutely a battle that we want to fight. On the CSR, so corporate social responsibility, GNI, the Global Network Initiative is a very good example. There are also other things that can be pushed to fight against censorship. For example, a few weeks ago, Pakistan issued a request, a tender for ICT companies to sell to the Pakistani government equipment to disrupt internet the use of the internet in case of security. And the civil society in Pakistan and institutions, NGOs all over the world put a lot of emphasis to the fact that companies should simply not comply with this kind of request from governments. So strong internal guidelines for companies in order to not abide to censorship or this kind of measure could be the way forward.
Thank you. I saw 3 hands raised, so I suggest that we take those 3 questions, then ask the panelists to respond, and then we can take another round of questions. So we'll have Morris first, then Peter, and then Juan.
Yeah, this is a question for Brankica, and I might just not have read the table right, but I thought I saw in 2010 or 2011 there were over 2,000 complaints. Is that correct? Something like that.
In 2010, 800, and last year almost 4,000.
Yes. Okay, and only 1 police investigation. So I'm very curious. What happened to the rest of those things? Were they frivolous complaints? Were some of them taken down? What happened to them?
Nothing happened. Just at the first stage hotline, they have a kind of expert to go through these reports, and
should we just take all the questions first and then have a response? Because some people might come back to the same issue. Is that okay? Peter?
Yes, actually, I have 2 quick questions, and the first one is also to Brankica, because you said that the police refuses the prosecution on the basis of that they have a very narrow understanding of what can be prosecuted, and it's some sort of physical incitement. And then you argued for considering the broader environment as well. So my question, in some different sense I see, but do you think that perhaps some more prosecution of some of those cases could take place in case of you successfully make an argument that the police as well, when considering what incitement can be physically dangerous, then some more prosecutions would take place? And the other question is about the intermediary liability, that would you agree trying to construe a very narrow understanding of such cases when the intermediaries can be held liable, both based on procedure and content? So what I have in mind is that to oblige with legal responsibility intermediary to take down stuff only if there is a preliminary injunction by court. So that would be the procedural safeguard. And the other thing, and here I come back to the danger test, when the material causes imminent danger, and here I leave open as a reaction to Frank's comment earlier, what danger of what, so it can be potentially the danger of discrimination as well, and also I add that the broader environment should be considered. So do you think that such narrow construction of when intermediaries would be held liable or responsible would be perhaps not too risky restriction? Thanks.
Thank you. My question, maybe it's a little bit dramatic, but aren't we witnessing at this moment a kind of a dramatic tension between public democratic regulation and private non-democratic regulation of the network? Because what I see, that there's a regulatory tendency towards, let's say, blaming the messenger. To the extent that the state is not able anymore to control the content at its origins, or it's reluctant to punish, let's say, the consumer of the content, the best option is to try to punish those who are in between, because first of all, they are very powerful in economic terms, so it's nice to go against them, and it doesn't raise the same problems of freedom of expression that would be raised in case we go to the origin or to the destination. So what I see is that the public power is trying to, let's say, get rid of certain kind of responsibilities, to put them in hands of private actors, but the price that we pay is that this regulation is not decided and not applied according to, let's say, democratic criteria. Because if we have had the experience of putting a video in YouTube, and to see that this video, it's been let's say, cancelled without any kind of explanation, due procedure, etc., etc., etc. And the other interesting thing is that whereas, for example, ISPs are reluctant to assume this kind of responsibility because they say, I don't want to be held liable for the things that I do transport, at the same time, they claim to have the right to control the packages that they are transporting through their networks. For example, this is the debate about net neutrality. So the question, first question, a general question would be, aren't we witnessing this big tension, and this is a very dramatic thing between democratic regulation and private regulation? And the other question is that, well, I think that we haven't mentioned this, there's this debate about SOPA in the United States, Stop Online Piracy Act. It seems that it has been stopped because of political reasons, but do you think that this debate, this kind of legislation like SOPA and PIPA can reach the European territory as well, or the political, let's say, European political landscape would not allow this kind of approach? Thanks.
Brankica, maybe you should go first with the first set of questions.
First to Maurice. I think nothing basically happened with those reports that are not proceed by prosecutors. They simply make busy these other subjects in this chain. You know, first hotline, which is going through complaints, and then decide which of them have, according to their knowledge, elements of criminal hate speech that can be put into criminal procedure, and then police investigating. They can then even question and do police investigation, and then if nothing is taken by prosecutors to the court, that is stopped, that is lost. But what Anya said, I think that the very fact that different subjects in the society are involved in this process contribute to some kind of you know, awareness and debate. Where the boundaries, and that is the answer to what Peter asked, I think I am not campaigning for how to say, practice of prosecutor office, which will pick up more cases in a way, you know, to just for the sake of cases. But it is the fact that they take the case only in case when there is physical attack. So the law says incitement, you know, incitement. So there we think that there should be more debate on interpretation of this regulation. What does it mean, you know? Is it really necessary that something happen? And this is obviously subject of debate and should be discussed by broader stakeholders how to deal with this. At the moment, I think there is something wrong if this is so huge disproportion by what is considered by public and users and even police as incitement, and then what is really happening.
Who wants to take both the second bit of Peter and Juan questions?
On SOPA PIPA, I would say that it was not stopped because there were some kind of political issues in relation to it, but because simply the proposal didn't work from a technological point of view in relation to the structure of the internet and for the purpose of the proposal, which was to provide a more effective measure to protect copyright online. So it was a complete failure from all this point of view. By the way, some of the things that were discussed in the SOPA PIPA debate you can find also in Europe in the context of ACTA, which is more global. But at the same time, what we think is that instead of more copyright enforcement, we need copyright reform. Because the new business, the internet and the new business model that the internet is offering are actually great opportunities to exploit, as you can see from the success in the independent music industry. But this is another story. Going back to the role of the law and the role of the society, and I'm really sympathetic to the point raised by Branchica on the role of the enforcement in the real world by public prosecutor in relation to crimes committed also online. Crimes are online and offline, and if laws are prescribing that these are crimes, public prosecutor should go after these crimes. So this is a concept which is out of every question, both in terms of the approach of intermediaries, both in terms of the general discussion around the values of our society. So I would really encourage to focus on the enforcement in the real world, because what you can achieve by taking down content online is only affecting the visibility of the content, but not the roots and the reason why the content came up online. And if it came up online, it means that in the real world there is a discontent that needs to be addressed.
Thanks. I just wanted to respond to a few points regarding SOPA. SOPA was indeed suspended, but because it couldn't get through the decision-making process in the US. What's interesting is that despite that, in June or July, the larger internet providers in the US are going to start voluntarily obtaining information from online surveillance in order to accuse consumers of breaking copyright law, with the ultimate sanction of firstly throttling their connection and then disconnecting them from the internet. So what isn't possible by democratic processes is still possible by voluntary measures sometimes. Another aspect of SOPA was the suggestion that people's domain names could be revoked. This wasn't possible via a democratic process, but it is quite high on ICANN's current agenda, and VeriSign, who runs .com and .net, have asked for the power to voluntarily, if they feel so fit, disconnect domain names anywhere in the world. And they've already started with a Canadian betting company that was disconnected, that had its domain name removed because it broke the law of the, I think, Commonwealth of Maryland. And SOPA proposed giving unlimited protection, liability protection, for any company that was a payment provider, service provider, advertising service, advertiser, search engine, domain name registrar, or domain name registry, for taking action outside the rule of law against individuals if they had a reasonable belief that US interests were being undermined. Is this possible? Well, WikiLeaks, MasterCard, Visa, and PayPal removed their payment services. Amazon removed their hosting. Their domain name registrar removed their domain name. President Sarkozy warned the French internet industry not to host the service in their country. It's very possible that SOPA can be implemented because it's being implemented in dribs and drabs anyway. And I think the point on net neutrality is very interesting, because the more, I think I tried to mention that in my initial presentation, the more governments go for the soft option of saying, you guys take care of it, you enforce the law, you deal with the problem, on the one hand, the less they can say to the internet providers, but you can't interfere with the traffic for your own interests. You can have it one way, you can have it the other way, but both governments, national governments and the European Commission, is saying you must interfere and you must not interfere at the same time, which is a confused message at best. Thanks.
Two issues that were raised before. That is, first, wouldn't it be better if providers were liable only when disregarding an order of an injunction of the judicial authority? This is a very complex issue, but let us not consider copyright, where maybe the discussion is a bit different. But I think in all other areas, in particular in the domain of hate speech that we are considering, this should, I definitely think that this should be okay. It should be the case. An issue is whether the providers have the obligation of informing the judiciary when they get noticed that such a situation is the case, and I would think so, as is also allowed by the e-commerce directive. In other areas, for instance, in data protection, you may wonder whether the judiciary may be substituted by the independent authorities, such as the data protection supervisors, and this may be the case. Concerning the other issue, whether the state, by making providers liable, would be renouncing his competence, I think that this is not necessarily the case. You must consider that providers, when they are not liable, they naturally tend to leave all content online. After all, their business consists in letting people access the content, and the most content is there, the better is for the providers, except when there is certain kind of particular environment, when the provider wants to implement particular rules of civility or of a particular address. When the state is imposing liability on provider, it is not renouncing his role, but I think the state rightly believes that by making providers liable, for instance, for copyright violation, enforcement is going to be more effective, unfortunately at the expense of the rights of the users. But I think it is another way of achieving political purposes rather than renouncing to those objectives. And the same may hold also with regard to hate speech.
Thank you.
I just want to say that I have to leave to catch train to Ljubljana. Goodbye to everybody and good luck. Bye.
Thank you so much for being here, Brankica.
Thanks for being here.
Any more questions? Morris?
Well, it was actually going to be a question for Brankica, so just make the comment instead. I am very much struck by that huge disparity between the number of complaints and the number of complaints that were judged to be meritorious from a legal point of view, which just makes me the reporting system seems to be something like trying to get the public to have input into what content is appropriately put online and what isn't, but they're getting it wrong virtually every single time, and it's just striking to me. I don't know what to make of it, but it's surprising.
Peter?
This is actually just a question for Marco. I was just wondering if you might be able to elaborate a bit more on the jurisdictional issues that and how Google handles these related to hate speech. As I understand, there's quite a number of cases that are still dealt with out of the US. Is that correct, or on these issues?
We respect the law in every jurisdiction we are operating if it's followed a due process of law, which means that, for example, if you take Germany as an example, in Germany there is a law which considers hate speech, illegal hate speech, any praising of Nazi content and of the Nazi regime. And this means that, for example, if we receive a court order asking us to remove this content from our search engine, we do it for the google.de site, which means that we try to narrow this kind of request to the jurisdiction affected by the court order and basically following under which the law is following under.
Can we have Peter's question first, and then we'll have feedback?
Actually, it might be rather just a really short comment that, as Brankica pointed out, that it sounds like in Slovenia as well as in Hungary, the situation is that the understanding what incitement means is just misunderstood. And it seems to be a big problem, and it seems to be a problem either we would rely on the providers to take down stuff which is really dangerous or bad, or if the police would intervene. And the misunderstanding seems to be that the police in Slovenia or in Hungary think that incitement took place if violence took place. And that's a police chief told it to me about a very vicious anti-Roma online speech, that no violence occurred as a result. So I had to explain to him that that's not part of the narrowest test. So I think that is an important thing to clarify, because it seems that law enforcement authorities just don't understand it. Thanks.
Shall we have this question first, and then we'll get back to you?
Kind of devil's advocate question. Isn't it possible that the police's scant reaction to those many times or more requests or complaint is somehow realistic in one sense? If there is a murder and they get complaint about murder, it is realistically expectable from police to handle all those complaints or requests in a rule of law manner, meaning near 100% of complaints can be somehow handled by them. It was still possible with complaints about print press. It was still possible even with television, simply because those were monitorable media types. The plyonka, the tape was there. The print press is by definition printed, so it is monitorable. Internet is by definition not monitorable. Internet is by definition infinite. Upload is possible from abroad. The hyperlink is content behind content behind content. So my question is, isn't somewhere realistic this dismal result? Question is a rule of law handling in the above-mentioned sense, is a rule of law handling possible by whatever definition, whether strict or not, of hate speech?
Joe, you wanted to respond first?
Yeah, I just wanted to give an alternative response to Stuart's question. My understanding, based on observation, is that when Google receives a complaint under the DMCA, under US law, then it de-indexes the site in question globally. So if you're in the UK or Belgium or Germany, you're under the DMCA as far as Google is concerned. On the other hand, if they receive an order regarding hate speech, for example, in Germany, then they'll remove the site for google.de, but it remains accessible for everyone else. So it's local and not local. Google has made great steps forward in relation to transparency, but we need to keep the pressure up because it's not quite there yet. Regarding Marco's comment about rule of law and transparency, this is the worst example I found, and there are much better ones, but there was a rather sad 3-line rant on a German website, which was removed from google.de. And the description on the Chilling Effects website is, a URL that otherwise would have appeared in your search was not displayed because that URL was reported as illegal by a German regulatory body. In other words, it was removed because somebody told us to, which I don't think is fantastic as transparency goes. But as I said, that is the worst example. To the last question that was asked, is privatization of the rule of law the option if the rule of law isn't the option? And I would say no. But the problem is that the political establishment won't recognize the fact. So we've got laws that are neither implemented nor not implemented. We just sort of look away, and we've got the worst possible mix at the moment.
Marco, did you want to respond as well?
Yes, in the sense that the comment made by Joe are not in conflict with what I said, because when I say that we need to comply with existing laws, I didn't mean to say that the existing laws are perfect. I mean, there are all the problems that are highlighted by Joe are a real problem that need to be addressed in the real world, in the policy debate, which in the end, for example, taking in consideration the discussion that we had today in the morning, was more focused on how to deal and probably to challenge the visibility of hate speech online. So I really want to challenge also the audience in thinking that sometimes we need to consider these two aspects, the need for intermediary to remain neutral and to follow the rule of law, but at the same time to try to put in a perspective the discussion that we have around hate speech and possibly policy making around hate speech. And if I can say something on that also, I would like to say that the difference in the numbers between the real action in terms of enforcement and the notice in relation to content online are also reflecting the huge sensitivity that we are having in these days around content online, without taking in consideration that the content online or the visibility of the content online is only the symptom, is not the disease of a more general problem in the society around the issues of the Roma or around the issues of the radicalization. So again, focusing only on the visibility of this content online is not helping us to solve the real problem.
Daniel has a question, and are there any other questions?
One quick comment on the discrepancy between the number of complaints and the actual number of cases taken by the police. According to official police data from 2011, there were 12 cases of defamation of race, nation, or religion, or incitement to hatred in the Slovak Republic. And as I showed you in the morning, there are literally hundreds, if not thousands, of such cases online. One of the reasons or explanations for this discrepancy is that, yes, number of those cases basically do not cross the threshold required for criminal law. But I wanted to show you another example in the morning, but I didn't have the time to do so, when actually police dismissed a criminal complaint of a case of using the term gypsy parasites in the election campaign. There were huge billboards in 2010 calling Roma gypsy parasites and, you know, really using this hateful content. And what the police said was the term gypsy parasite is not incitement to hatred or defamation of race or ethnicity. It's just a legitimate discussion about misuse of social benefits by Roma. So if the police reacts, you know, to such, at least to me, quite open expression of hatred, what you could expect from the public, you know. And this was not online, this was used in the election campaign.
Sir?
Well, I wanted to make a comment on this part of the discussion. It seems to me that the question of the intermediary liability is a question that becomes more difficult if we try to face it as a special question. My impression is that the way to start really to face the question is to go to the same deep principle on which all the hate speech and the equilibrium with freedom of expression that we discussed this morning are dealt with. So a view of equilibrium and of rule of law. For instance, an example that comes from the European regulation on audiovisual. In the Audiovisual Media Service Directive, you have a different regulation for what is called linear and non-linear services. Well, that's it's not because they are different the principles are the same, but the regulation adapts to reality. I think that this should be a guideline in a way also in facing the internet responsibility problem. Clearly that if you have a newspaper, you have an editorial board, a responsible, it's easier to, and we know how to apply immediately. But the deep principle we should be looking for are the same. I'm not saying that, that there are easy solutions, but somehow we should always look at the same equilibrium principle, looking for the solution that we, while we move toward the internet. That's my feeling about this part of the debate.
Did I see one more question this side? No. Peter, did you have one more comment? Or?
To show that the Slovakian case took place in Hungary as well. Election campaign, extreme right-wing party, in an election advertisement was talking about gypsy crime, and the public media rightly refused to air the advertisement as a good example of some sort of self-regulation, but the National Election Committee said you must air the advertisement. So that is just the environment.
Giovanni, I think you wanted to respond, no?
No, I just have, it seems to me that there are different issues that we are maybe putting together. So one issue is, I think, when providers are liable if they allow illegal contents on their websites. And we have different solutions. I personally believe that they should not, generally they should not be liable unless there is an order by an authority to remove the content. They may have other obligations which are related to that. A different issue is when they should be liable if they take out content which is not illegal. And here we may have different views. The main one view may be they are never allowed to take out a content which is legal. So a judge should decide in any case. Another view is that they may have some kind of say, editorial freedom and building different spaces online according to different policies they make public when in connection with those particular spaces. So I think that I myself am not clear on what is the best choice. While I believe that it is a bad idea to make a provider liable for hosting illegal materials, I don't have clear ideas on when they should be liable for taking down material which is not illegal. And my view would be that there are fundamental human rights that must be respected and may also override the contract that the service contract that the user signs when registering to a website. But I think that some level of self-regulation by the provider on that would be, I would say, inevitable. But this is my opinion on that.
Do any of the other speakers want to respond? Not immediately. Are there any more questions? So I'm going to take even though I know it's been a really long day, I'm actually going to do this to you and ask a question myself. Because I want to slightly turn things on their head. I've been quite struck today how I think for as long as the internet existed, we've been arguing that intermediaries are not media, right? That we should make a distinction between the two. And yet, a lot of what we've discussed today, and I think a lot of the solutions that are being proposed, and a lot of what is actually happening in practice, especially this increasing tendency to make terms of service a safeguard against anything and everything, actually means that more and more intermediaries are acting like media and constantly self-censoring in a way, except that they don't do this on the basis of some code of ethics and some larger public interest issue, but mostly because of commercial interests. I would like to hear from the speakers, what does that do to the open nature of the internet in general, especially because the exact way in which this happens is very different from country to country. What does that do to the open nature of the internet in general? And what effect does that then in turn have on free speech in general? Because all of this is supposedly happening to protect us from harm and use the reasonable restrictions. But how does perfectly legitimate space, how is that being pushed into a corner in the course of all of this as well? Or am I being too pessimistic? Any responses? Marco?
I would like to go back to the introductory speech from Frank and his work as a rapporteur. The guidelines that was given by him to me makes a lot of sense. This is exactly the framework in which we all should, talking about the industry, we all should move, both in terms of interacting with policymakers and so suggesting to them a structure which works in terms of effectiveness, like notice and take down, but also taking in consideration the right balance that we need to strike between fundamental rights. So I think we already have the answer, and the answer is in the introductory speech to this morning from Frank.
Just following on that, I think my impression is that we should take a different approach toward different ways of hosting content on the internet. So, for instance, if I am just purchasing some space for Amazon or from Google to put my stuff online, I think no control should be allowed on whatever I just put there on my computer, on my remote disk, which is hosted by Amazon or by Google. When I made materials available on a website which I personally manage, again, I think that basically no control should be allowed unless there is a judicial order to remove some stuff. When I am involved in the repository online, I think that maybe some kind of restraint may be used, but why? I think that the need to restrain, or the opportunity of restraining, may depend on the fact that the users of the repository may be exposed to the material that I put there without their choice. So basically they are forced to be exposed. It's like putting stuff on a wall. So maybe we can, and if I participate in a forum which is devoted to a certain subject, again, there may be even more constraints. So that if I put something which is not related to the subject of the forum, then the organizer of the forum may take out my stuff. So I think that it's very difficult to find a general solution, but maybe by reasoning on the kind of function that is exercised by each space that we find on the internet, we may find the appropriate constraints that should govern that particular space.
I like the fact that just as I switched off the microphone, he said, maybe, I don't know. And I think that's a good conclusion for this session, which clearly does not have any final conclusions. Thank you very much to the speakers, to all the questions and for listening. And I look forward to seeing you again tomorrow. Thank you.